Episode 6, Constitutional Rights, Due Process, and the Writ of Habeas Corpus. Frederick Douglass said, "God has no children whose rights may be safely trampled on."
My name is Michael Heavey. I'm a retired judge and CEO of Judges for Justice. I'm in Philadelphia in front of Independence Hall, where the Constitution was signed in 1787.
This is a Howard Chandler Christie painting depicting the signing of our Constitution on September 17th, 1787. The United States Constitution stands as the supreme law of the land. Among its most powerful promises are the 5th and 14th Amendments, which declare that no person shall be deprived of life, liberty, or property without due process of law. One of the first lessons taught in law school is that due process means fundamental fairness. Over the years, the U.S. Supreme Court has clarified certain promises of fairness that the state owes to a defendant. Brady v. Maryland is a landmark 1963 U.S. Supreme Court case that established the prosecution's obligation under the Due Process Clause of the 14th Amendment to disclose evidence favorable to the defense. The court's key holding in Brady mandates that prosecutors must disclose any exculpatory evidence that could either prove a defendant's innocence or mitigate their sentence, if it is material to guilt or punishment. A Brady violation occurs when the prosecution, whether intentionally or unintentionally, fails to disclose material exculpatory evidence to the defense as required by the Due Process Clause. Such violations can lead to new trials, overturned convictions, or even dismissal of charges. In addition to the protections afforded by the Due Process Clause of the 14th Amendment to the United States Constitution, the Pennsylvania Constitution expressly guarantees the privilege of the writ of habeas corpus. This writ serves as a fundamental safeguard against unlawful restraint or imprisonment, ensuring that individuals have the right to challenge the legality of their detention before a court of competent jurisdiction. The writ of habeas corpus is not an automatic release from incarceration. Instead, the issuance of a writ only starts a judicial inquiry into the legality of a person's detention. It does not guarantee release. It ensures that the person's imprisonment is subject to judicial scrutiny to protect against wrongful or unconstitutional imprisonment. The Pennsylvania Constitution states, "The writ of habeas corpus shall not be suspended." We will see in this episode 6 that the Court of Common Pleas of Lehigh County has, on 2 separate occasions, imposed a due diligence requirement upon Patty Rorrer and denied her judicial review of her claims. Such actions effectively constitute an unconstitutional suspension of Rorrer's constitutional privilege to seek judicial review through the writ of habeas corpus. In episode 4, titled Police Misconduct, we introduced eyewitness Walter Troutman. On December 15, 1994, the day Joann Katrinak and her baby Alex disappeared, Troutman contacted the Pennsylvania State Police to report a disturbing incident he had just witnessed. This is a December 23, 2002 statement from Walter Troutman. In it, he describes what he witnessed on December 15, 1994, the day Joann and Alex went missing. Troutman details his attempts to report the incident both on the day it occurred and multiple times afterward to the Pennsylvania State Police. You are looking at a Pennsylvania State Police report completed by Trooper Robert V. Egan III. The report is dated November 27, 1995, about 11 and a half months after the murders of Joann and Alex Katrinak. Please note that officers receive training in report writing and taking witness statements as a fundamental part of their police academy education. It's estimated that nearly half of an officer's duties involve writing reports. Trooper Egan is writing this report in response to Walter Troutman's complaint of abuse filed by Walter Troutman's attorney. In the opening sentence, Egan misspells Walter Troutman's name as Troutman, like the fish, instead of the correct spelling, Traupman. Additionally, the report inaccurately describes Troutman as a 55-year-old white male, when in fact he was 69. According to Trooper Egan, Walter Troutman had visited the Pennsylvania State Police Station in Bethlehem approximately 15 times before this incident. If true, each of those visits should have been documented in a witness report. Yet, in the Katrinak murder file, there isn't a single report, other than this one, which records Troutman visiting the police station. We believe that as many as 15 reports related to Walter Troutman may have been destroyed. Egan then talks about receiving a letter from Troutman. Quote, Troutman even wrote this officer a letter. Included in the letter was drawings of the man and woman involved in the argument on Lloyd Street. The letter has since been destroyed because it was of no investigative value. End quote. In Pennsylvania, it is a crime, a misdemeanor, to destroy or alter evidence. If Trooper Egan intentionally misspelled Walter Troutman's name or destroyed Troutman's witness reports or disposed of the letter from Troutman containing drawings, he could potentially be guilty of a crime. Eventually, Walter Troutman and his account were discovered. Judge William E. Ford determined that the Commonwealth had committed a Brady violation by failing to provide the defense with crucial evidence about eyewitness Walter Troutman. Following his finding that the Commonwealth had violated Patty Rorrer's constitutional due process rights, Judge Ford turned to a critical question on June 24, 2009. Would the failure to disclose information about Walter Troutman be grounds to give Patty Rorrer a new trial? PCRA stands for the Post-Conviction Relief Act, which allows convicted defendants to seek relief after exhausting all appeals. In his written opinion, Judge Ford correctly stated the law. Quote, "The PCRA provides relief for those convicted of crime who offer exculpatory evidence which was unavailable to them at time of trial. A PCRA petitioner seeking relief under this approach must establish that the exculpatory evidence would have changed the outcome of the trial if it had been introduced." End quote. He made the following factual determination. Quote, "Defendant's hairs, stained with blood, were removed from Mrs. Katrinak's seatback by law enforcement during this investigation." End quote. Judge Ford was able to factually find that Defendant Rorrer's hairs were found on Joann Katrinak's car seat because of DNA testing. At Patty Rorrer's 1998 trial, the jury was told that one of the 3 Q1 hairs found on the victim's car seat in December 1994 was a perfect mitochondrial DNA match to Rorrer. Also, the jury was shown that another one of the Q1 hairs was a perfect nuclear DNA match to Rorrer. The judge reached the following legal conclusion. Quote, "In light of this conclusive DNA evidence, the testimony of Walter Troutman could not change the outcome of this case. Therefore, the defendant is not entitled to relief under the PCRA." End quote. However, evidence obtained in 2015 raises substantial doubt regarding the conclusiveness of the DNA findings. An excellent resource on this case is Tammy Mal's book, Convenient Suspect. In 2015, during her research for her book, Tammy filed a Freedom of Information request with the FBI concerning the Patty Rorrer case. The FBI responded to Tammy's information request, providing a collection of documents she received on July 27, 2015. Among them, this document, an FBI memo that was a potential game changer. Paragraph 10A of the FBI report states, quote, "Found in car on driver's headrest. 3 hairs 9 inches long. No roots attached. And blood on 2 of the 3. PSP lab reported hair not that of victims. Presently at FBI lab for DNA analysis." End quote. As our viewers may recall, the 3 hairs the FBI agent is referencing are the 3 Q1 hairs, which were sent to the FBI lab on July 12, 1995, for DNA testing to determine the source of the blood on the hairs. If this 1995 FBI report is accurate in stating that the 3 Q1 hairs had no roots attached, then the Q1 hair nuclear DNA tested in 1997, which contained a hair root, could not have been authentic, meaning it was not one of the original Q1 hairs collected from Joann Katrinak's driver's seatback in 1994. Judge Ford had already found a Brady violation in the case due to the non-disclosure of Walter Troutman. Now, new evidence had surfaced, suggesting the Commonwealth might have withheld yet another critical piece of exculpatory evidence, an FBI report. On September 24, 2015, armed with this new evidence, Patty Rorrer's attorney, Craig Neely, presented her 4th PCRA petition before the Honorable Douglas G. Reichley in the Lehigh County Court of Common Pleas. Eight months after the petition was filed, on May 26, 2016, Judge Reichley dismissed the No Roots Attached petition, citing it as untimely. With this ruling, Judge Reichley made it clear that he wouldn't be finding a second Brady violation or addressing the substance of the allegations. Judge Reichley dismissed Patty Rorrer's fourth PCRA petition as untimely, despite her compliance with the PCRA's time limits. He argued that Rorrer failed to act with diligence, rendering her petition untimely. Judge Reichley's reasoning implies that all criminal defendants must, as part of their due diligence, submit FOIA requests to the FBI. Judge Reichley disregarded a fundamental principle of the U.S. Constitution. According to the Supreme Court's ruling in Brady v. Maryland, the Due Process Clause of the 14th Amendment mandates that the prosecution disclose exculpatory evidence to the defense. It is not the defense's responsibility to unearth it themselves. According to the Code of Judicial Conduct, judges are expected to be diligent and demonstrate thoroughness in their work. One sign that a judge hasn't fully considered the matter before them is when they make errors in the facts. At one point in Judge Reichley's opinion, he notes, quote, "This document provided by the FBI, which is undated and unsigned, appears to be a draft report regarding the hair sample evidence obtained in the defendant's case. Within this draft report, it is noted that 3 hair samples had no hair roots." End quote. Our viewers know that Judge Reichley is incorrect about an important fact. The FBI report stated that the 3 hairs had, quote, "no roots attached," end quote. The judge made a significant error. The FBI memo stated, "no roots attached," not "no hair roots." In our view, this mistake suggests he may not have read the FBI document. He appears to not have exercised the level of diligence and thoroughness expected of a judge. On March 6, 1998, Patty Rorrer was convicted of 2 counts of aggravated murder. A few days later, on March 10, 1998, Lehigh County Assistant District Attorney Douglas Reichley appeared on WFMZ TV 69 News.
You can successfully obtain a prosecution based on the DNA evidence, perhaps exclusive of anything else. In this situation, we didn't have an eyewitness, we didn't have a confession, we didn't have any fingerprints, anything like that. So you really relied upon this breaking-edge technology.
According to Pennsylvania's Ethical Rules for Judges, the Code of Judicial Conduct, Judge Douglas Reichley was obligated to disqualify himself from presiding over the Patty Rorrer case because he served in government employment as a Lehigh County prosecutor and he publicly expressed in such capacity an opinion concerning the merits of the Patty Rorrer case.
You can successfully obtain a prosecution based on the DNA evidence, perhaps exclusive of anything else. In this situation, we didn't have an eyewitness, we didn't have a confession, we didn't have any fingerprints, anything like that. So you really relied upon this breaking-edge technology.
Despite the mandatory rule requiring Judge Reichley disqualify himself, he did not step aside from the Patty Rorrer case. This decision raises concerns regarding his impartiality. In Pennsylvania, the appeals court between the trial court and the Supreme Court is called the Superior Court. This is page 1 from the Superior Court of Pennsylvania's decision in the Patty Rorrer case, rendered on October 26, 2017. It is the appeal of Judge Reichley's decision. The first paragraph of the Superior Court decision contains 2 sentences and summarizes the holding of the court, that being, quote, Patricia Lynn Rorrer appeals the PCRA court's dismissal of her 4th PCRA petition as untimely filed. We affirm. End quote. In reviewing the decision, there are at least 22 factual errors, some minor, others significant. The 3-judge panel deciding Patty Rorrer's appeal consisted of Judge Bender, Judge Bowes, and Judge Shogan. The decision was written by Judge Bowes. Let's look at a few factual errors in the account. Although it's true that Patty Rorrer and Andrew Katrinak, Joann Katrinak's husband, had once been romantically involved, it's inaccurate to state that their relationship ended in May 1993. All parties agree that Patty Rorrer and Andy Katrinak ended their relationship in 1989, not 1993. In fact, on May 29, 1993, Andy and Joann were married. The Superior Court states on page 3 of their decision, 3 seatback hairs that had roots were mounted on microscopic slides, and the slides were sent to the Federal Bureau of Investigation, FBI, for mitochondrial DNA testing on July 11, 1995. Viewers who have watched episode 5 already know how this single sentence contains multiple inaccuracies. You are viewing an FBI evidence receipt form. The laboratory number 507-12022 in the upper right corner has a specific meaning. The 5 represents the year, 1995. The 07 indicates July. The 12 refers to the 12th day of the month. Therefore, we know the evidence was received on July 12, 1995, not on July 11. It's important to note that contrary to the Superior Court's statement claiming the 3 hairs were mounted on slides, the evidence was actually described as 3 unmounted hairs. Contrary to the Superior Court's statement, it is important to note that there's no mention of any roots on the hairs. The Pennsylvania State Police, PSP lab, specifically sought nuclear DNA testing for what appeared to be blood on the hairs. In 1995, mitochondrial DNA testing for hair evidence was unknown and did not become available until 1996. In a single sentence, Judge Bowes makes 4 incorrect statements of fact. No hairs with roots were observed in 1995. The 3 hairs sent to the FBI were unmounted, not mounted. They were sent for nuclear DNA testing, not mitochondrial DNA, and they were sent on July 12, 1995, not July 11. The most damaging inaccuracy, however, is Judge Bowes' assertion that the cigarette butt found near the two bodies was a DNA match to Patty Rorrer. Judge Bowes makes this claim not once, but 3 times in her opinion. But here's the truth. The cigarette butt has never been tested for DNA. Not then and not now. In fact, as of December 2024, 30 years after the tragic murders of Joann and Alex Katrinak, 3 pieces of evidence recovered from the crime scene have not been DNA tested. These items include a cigarette butt found near the victims' bodies, a torn fingernail fragment found on Joann Katrinak's chest, and a human hair approximately 5 inches in length found clutched in Joann's right hand. All 3 can be tested for mitochondrial DNA. The cigarette butt can also be tested for nuclear DNA. When reading a court opinion, one should be able to trust the accuracy of its facts. Yet, Judge Bowes falsely stated no less than 3 times that Patty Rorrer's DNA matched a cigarette butt found near the bodies of Joann and Alex Katrinak. Judge Bowes finds as a matter of law, quote, Appellant knew at her 1998 trial that the FBI had conducted DNA testing on the seatback hairs and her exemplar hairs. Thus, Appellant did not put forth reasonable efforts to obtain the FBI reports. She readily could have accessed them at any time after she was charged in 1997, almost 20 years before she decided to do so. Her invocation of Section 9543B12 therefore fails. End quote. In reality, the facts reveal that Patty Rorrer went well beyond making reasonable efforts to obtain FBI reports related to her case. Over the years, both Rorrer and her supporters have submitted multiple Freedom of Information Act requests to the FBI. On one occasion, the FBI acknowledged locating 1,935 pages of reports relevant to her request, but released only 22 pages. Remarkably, the only request that uncovered the No Roots Attached report came from author Tammy Mal, who filed it in 2015. In our view, Judge Bowes failed to adhere to the clear dictates of the U.S. Supreme Court. The burden lies with the prosecutor, not the defendant, to uncover and disclose evidence that could prove innocence. In 2021, a federal judge issued an order requiring the FBI to release documents to Patty Rorrer. Among the disclosed materials was a crucial document that Patty Rorrer herself uncovered on February 28, 2022. This is the document she found. It is an undated page from the bench notes of Dr. Joseph A. DeZino of the FBI laboratory. Just like the discovery of the No Roots Attached FBI report, this Q1 hair not artificially treated lab note emerged as a potential game changer, and it raised the possibility of yet another Brady violation in Patty Rorrer's case. Presiding over Rorrer's 5th PCRA petition was Judge Anna Christie M. Marks of the Lehigh County Court of Common Pleas. On June 17, 2024, Judge Anna Christy M. Marks of the Lehigh County Court of Common Pleas ruled on Patty Rorrer's fifth Post-Conviction Relief Act petition. Judge Marks denied relief and ordered Patty Rorrer's fifth PCRA petition dismissed as untimely. This is page 1 of the 4-page order. This is the second page of Judge Marks' June 17, 2024 order. This is the third page of Judge Marks' 4-page final order. Judge Marks states on page 4 of her order, moreover, this court finds that the defendant's claim that the laboratory notes rebut the Commonwealth's evidence of guilt is disingenuous, as the laboratory notes do not tend to establish the defendant's innocence in light of the mitochondrial and nuclear DNA results. If the Q1 hair tested by Dr. Dizino through mtDNA analysis was not artificially treated, it could not have belonged to Patty Rorrer in December 1994, because her hair was artificially treated, permed and bleached in December 1994. More importantly, it could not have been one of the original Q1 hairs lifted from Joann Katrinak's car seat, because the evidence indicates the car seat hairs were bleached blonde. To see all the evidence that the hairs lifted from Joann Katrinak's car seat in 1994 were bleached and blonde, the viewer should go back and watch episode 5. This raises the troubling possibility that Rorrer's hairs were switched into evidence. This is a strong indicator of Patty Rorrer's innocence, not disingenuous at all. In a footnote on page 3 of Judge Marks's decision lies the pivotal aspect of her ruling. She concludes that the Dizino bench note, stating that the Q1 hair was not artificially treated, cannot be considered because it was not raised in a timely manner. Judge Marks stated on page 3 of her order, quote, "As such, if the defendant had not been in possession of these notes, it is inconceivable to this court that the defense would not have requested them or filed a motion to compel." End quote. Actually, prior to her 1998 trial, Rorrer's attorneys had requested discovery of all reports along with corresponding lab notes related to the hair and DNA evidence. However, for some reason, Judge Marks was unaware of this request. Judge Marks concludes this portion of her order by finding, consequently, this court finds that Dr. Dizino's notes are not new and were readily discoverable at the time of trial through the exercise of due diligence. Judge Marks disregarded a fundamental principle of the U.S. Constitution. The Due Process Clause of the 14th Amendment mandates that the prosecution disclose exculpatory evidence to the defense. It is not the defense's responsibility to ask federal judges to order evidence be produced prior to trial. In the first Brady violation, the Commonwealth withheld the testimony of eyewitness Walter Troutman, who saw Andy Katrinak arguing with his wife Joann on the day she disappeared. If that were true, Patty Rorrer could not have committed this crime. If Troutman was correct, it negates the prosecution's theory that Joann was kidnapped from her home. Patty Rorrer had never met Joann Katrinak and had no idea what she looked like, making it nearly impossible for her to intercept Joann while she was driving around the Allentown area. In the second Brady violation, the Commonwealth failed to disclose the FBI report indicating that the Q1 hairs had no roots attached. If true, it proves that the Q1 hair tested in 1997, which had a root, was not an original Q1 hair. The third Brady violation is the Commonwealth withholding a bench note from Dr. DeZeno, which stated that he examined a Q1 hair that had not been artificially treated. This contradicts the evidence that the original Q1 hairs, lifted from the victim's car seat, were bleached blonde. The Pennsylvania Constitution provides a guarantee that individuals challenging their incarceration have the right to judicial review through the writ of habeas corpus. Given this protection, how is it possible that both Judge Reichley and Judge Marks dismissed Patty Rorrer's fourth and fifth PCRA petitions without conducting any judicial inquiry? Earlier, we discussed Pennsylvania's Post-Conviction Relief Act, or PCRA. As outlined in Section 9542, the PCRA includes and encompasses the writ of habeas corpus. The Pennsylvania Supreme Court has determined that the PCRA can govern post-conviction review and provide a statutory framework so long as access to judicial review is preserved. Therefore, Patty Rorrer's fourth PCRA petition included a request for a writ of habeas corpus. However, Judge Reichley dismissed the petition without conducting any judicial review, citing a lack of diligence and deeming the petition untimely. Similar to Judge Reichley's ruling in 2016, Judge Marks in 2024 also decided to deny judicial review of Rorrer's claims. She ruled that Rorrer could have obtained Dr. DeZeno's lab notes at the time of trial through the exercise of due diligence. Judge Marks found that Rorrer failed to do so, and the fifth PCRA petition was deemed untimely. The PCRA imposes specific time limits for filing petitions. Generally, they must be submitted within 1 year of the date the conviction became final. In Rorrer's case, her conviction became final on April 11, 2000. Therefore, any PCRA petition filed after April 11, 2001 is considered untimely, unless it qualifies for an exception to this rule. So, an exception provides that if the facts upon which the claim is predicated were unknown to the petitioner and could not have been ascertained by the exercise of due diligence, then any petition invoking an exception provided in paragraph 1 shall be filed within 1 year of the date the claim could have been presented. Patty Rorrer invoked this exception, filing her fourth and fifth PCRA petitions within 1 year of discovery. Patty Rorrer uncovered this exculpatory FBI report in 2015 through a Freedom of Information Act request made by author Tammy Mal. Rorrer promptly filed her fourth PCRA petition within 1 year of this discovery, submitting it in 2015. Despite Rorrer filing her petition within 1 year of discovery, as allowed under the exception to the PCRA time limit, Judge Reichley ruled that she had not exercised diligence and deemed her petition untimely. In 2017, the Appellate Court upheld Judge Reichley's decision, concluding that Patty Rorrer could have readily accessed the No Roots Attached FBI report at any time after being charged in 1997. In 2021, a federal judge ordered the FBI lab to produce discovery related to Patty Rorrer's case, which led to the disclosure of an FBI lab note stating Q1 hair, not art RX'd. Rorrer received this document in 2022 and filed her fifth PCRA petition in 2023, adhering to the PCRA time limits by filing less than a year after obtaining the discovery. In 2024, Judge Marks denied Patty Rorrer a judicial inquiry and dismissed her fifth PCRA petition, despite Rorrer filing her petition within 1 year of discovery. Judge Marks ruled that she had not exercised due diligence and deemed her petition untimely. Judges Reichley, Bowes, and her colleagues at the Superior Court, along with Judge Marks, denied Patty Rorrer judicial review of her claims in her fourth and fifth PCRA petitions, citing a failure to exercise due diligence. These judges appear to have suspended the constitutional right of habeas corpus. The framers of Pennsylvania's constitutional guarantee of habeas corpus would likely have disapproved of any statute granting judges a vague and subjective standard to sidestep their constitutional duty to conduct a judicial inquiry. Judge Ford followed the United States and Pennsylvania constitutions by finding a Brady violation and giving Patty Rorrer judicial review of her claims. The other judges, maybe not. However, we leave it to our viewers, particularly those residing in the Lehigh Valley, to form their own conclusions.
This ends episode 6. In episode 7, we will look at what Judges for Justice thinks might have happened in this case.